Buenos días.
Good morning. Good morning, colleagues. Distinguished representatives of the Croatian delegation, members of non-governmental organizations, I welcome all of you and will continue today in public session with this meeting of the Human Rights Committee, the aim of which is to look at the periodic report of Croatia. Yesterday afternoon we asked a number of follow-up questions and we'll begin today with responses to those from the distinguished delegation. Following that, we will undoubtedly move on to the second section of the list of issues. Without further ado, then, Madam Head of Delegation, I give you the floor so that you can offer your responses. You have the floor.
That is very nice. I wish you all a good day, respected members of the committee, Mr. Chairperson, respected guests and colleagues. I propose that we continue with the answers to the questions that were asked yesterday. Allow me to begin with the introductory part of the answer to the question which has to do with whether the Republic of Croatia has established a clear structure for the protection and realization of human rights and for monitoring the effects in trying to achieve the protection and realization of human rights. As this area is very broad, it is impossible to give a short and clear answer to this question without the answer becoming boring. So we will only take out the clear structure which demonstrates in which way we identify and detect the areas in which the state needs to provide a guarantee for the protection and promotion and implementation of human rights, and the way we monitor the follow-up. Namely, in Croatia, there is an established system of evaluating the effect of rules and regulations, and that is a procedure which is prescribed for all legislative regulations. And the aim of this procedure is to detect the areas in which it is necessary to intervene with a legal norm in order to establish the measures on the basis of which it is going to be established whether the effect of the amendment of this rule has been achieved. As for the area of human rights protection, when creating the legal norms which are supposed to realize or to support the realization of human rights, we always include in the working groups working on the amendments of the respective regulations also the structures of the NGOs, that is, of organizations of civil society, and they in fact demonstrate in the best way which areas need protection. At this point, I'm very proud to say that we have an extraordinary good cooperation on drafting the act on the protection of persons with psychical disorders, which has been done with an NGO which deals with the protection of persons with psychosocial difficulties and disabilities. And we were able to achieve the most important effect in the end. We have not only a very good regulation which changes the protection of these persons from the medical sphere into the sphere of human rights, as we've pointed out in our introductory speech, but we've also achieved the effects which we wished for, that the problems of persons with psychosocial disabilities become visible in society, that we raise the awareness, and that not only the ones who are primarily dealing with these issues, that is doctors and medical professionals, but also the rest of the community become aware of this issue. Following up or monitoring the regulations that have been amended is the obligation of the ones who have done the amendments, and we have established a whole system of statistical monitoring, and it is the objective, the task of the ones who ratify, who adopt the regulations, the amendments of the regulations to the monitoring. The colleagues in the ministries often also conduct social research in order to identify whether the objective of the act has been achieved. And as for the structures established for the sake of monitoring the effects and its realization, in the Republic of Croatia, a whole range of professional bodies has been established and commissions for monitoring and realizing the measures and activities for the protection or realization and implementation of human rights, such as the Human Rights Commission, a commission for the inclusion of the Roma population. So there are structures in place and the effect is being monitored. And in the end, I think that the content of the regulations which we have amended from the report up to date demonstrate that the areas have been included which truly enable the implementation or the protection of human rights and raising them to a higher level than it used to be. So it demonstrates that we have detected the areas in which the interference of the state was necessary with the regulations. I propose that in the structure of the most vulnerable groups and the way this is structured and the way it effectively operates, I propose that the head of the Human Rights Administration in the Republic of Croatia, Mr. Stojanovic, takes the floor. Thank you. So, as a follow-up to what we've just heard, I would like to briefly inform you that according to the report on the implementation of the National Program of the Protection and Promotion of Human Rights for 2013, it is visible that in all areas of operation, mostly activities have been implemented or being actively implemented, which contribute to the establishment of the human rights system in the Republic of Croatia. Out of 188 measures which had to be implemented in 2013, or 158 have been implemented, 2 of them have been partly implemented, and 18 measures have not been implemented for objective reasons, such as the lack of administrative capacity and the reduction of the budget funds. Important steps have been made forward in the human rights area in further rationalization of the system, of reduction of the number of judiciary bodies, also in the protection of the right to trial within a reasonable period of time, the number of cases which legal judicial advisories content can make independently has also been increased. And the new institution of a commissioner for informing has been introduced as an independent state body for the protection of the rights to the access to information, which protects, monitors, and promotes the right, constitutional right to access to information. The protection of the rights and dignity of the workers. We have a new act on minimal loan, which in a good way establishes the procedure of the height of the minimal wage in order to enable a more effective implementation of the interests of the workers which have the minimal wage in order to prevent the risk of poverty of workers. The evaluation of the total implementation of this national plan and its effect upon the status of human rights in Croatia is conducted by our Office for Human Rights and National Minority Rights. The evaluation is based on professional analytical report, which is drafted by the task force for the evaluation of this program, consisting of professionals from the academic community and the civil society organizations. The first evaluation is conducted in the first quarter of this year and the second after the end of the implementation of the national program. The report contains an assessment of the implementation of the objectives of the national plan, the implementation of the efficiency of individual measures, the assessment of the effects of the national program upon the status of human rights, and recommendations of the key objectives of the government of the Republic of Croatia for the purpose of the protection of human rights. This report on the implementation and effects of the national program serves as a basis for making a new national program of the human rights protection and promotion for the period 2017 till 2020. And linked with the indicators, which was one of the questions yesterday, the national program for the human rights protection and promotion has also defined a certain number of measures implemented for each individual objective, so that linked with the objective of raising the openness and awareness of the public administration, a module of education has been introduced on conducting a public discussion on the implementation of education, other regulations and bylaws, and it's including into the program of a state school for public administration. The Office for Non-Governmental Organizations, in cooperation with the State School for Public Administration, has asked for a special module of education and conducts and organizes a one-day seminar on how to prepare and implement an efficient discussion with interested public in the procedures of ratifying or preparing laws and bylaws and other regulations. The seminar is intended for the state and local officers working on the operations of informing the public on legal matters, legal issues, and issues of cooperation with NGOs and other civil society organizations and interest groups.
There were 6 seminars in 2013 that had 88 participants. The issue was focused on the recommendations under the international treaties As for the recommendations under the international treaties, I would like to point out that those have been integrated in the national documents. For example, the recommendations under the UN Convention on elimination of all forms of racial discrimination, and the report, UPR report, on the human rights have been integrated into the National Program of Human Rights Protection and Promotion. As for the recommendation of the Committee for Combating Racial Discrimination, the state, as a state party of this convention, has enforced measures against all hate crimes and other forms of violence that are connected with ethnicity, ethnic origin, in particular to enable victims fair and fast legal remedy. This measure has been defined by the National Program for Human Rights Protection and Promotion, as well as the National Plan for Combating Discrimination. Croatia has the new criminal code, and in it the racial discrimination has been sectioned as two criminal offenses. The criminal offense of violation of equality and the criminal offense on public promotion of hatred and violence. There are a lot of information. I will move on. The training of judges and state attorneys on human rights. The Office for Human Rights and Rights of National Minorities has conducted, in cooperation with the Judicial Academy, during 2012, the training of judges, state attorneys, and other stakeholders in the implementation of the Act on Combating Discrimination. In total, there were 192 professionals participating in such educational trainings. At the end of 2014 and beginning of this year, there was a review of the project to evaluate the impact of the program on the protection against discrimination related to the training. This review has indicated that most of the participants found that they have increased their skills during the training, meaning the identifying the discrimination, processing the claims, understanding the role of other stakeholders in the implementation of the Act, and so on. It is important to point out that these were one-day education trainings, and their impact, therefore, was relatively low in terms of affecting the professional life. It is important to point out that the participants of the training sessions have highlighted that it would be useful to continue such training sessions, and of course the Office for the Human Rights will continue to conduct them. The Judicial Academy continued with the training of judges and state attorneys in the last year, and according to their data, 350 participants were present for such trainings for judges and state attorneys. And if we want to focus on that particular trainings, there were 200 participants, out of which 140 judges and 60 state attorneys. So these are the details. The State Administration School conducted 7 training sessions on human rights, which had 90 participants. If we compare the situation with the number of training sessions in 2011, we can see that there is a 50% increase. National Plan for Combating Human Trafficking. The measures for the National Plan for Combating Human Trafficking have been focused on the training of police officers, both criminal department and borderline department, and also police college students. In 2013, at the police college of the police academy, there were 15 lessons covering human trafficking, including the identification and assistance and support to the victims of human trafficking. The course for the borderline police, there were 3 courses in total. In total, 262 participants were attending those borderline training sessions. The basic course for traffic police officers, there have been 3 courses with 91 participants. Specialist courses for juvenile delinquency and crime against the family and minors, there were 33 participants attending. The police directorate has organized specific operational training for police officers that combat organized crime and illegal migrations. There were 6 courses for 6 police departments, with a total of 570 police officers attending. Also, within the project of human trafficking project concerning the migrants, illegal migrants, financed by this office, there were on the 30th of September and the 12th of November, educational workshops for 25 police officers. There is a lot of information. There is an action plan for removing obstacles for the integration of aliens. There are measures that will integrate the foreigners or aliens into the Croatian society, ensuring their equal status in economic, social, and social life. And since I should be more brief, I would like to use this opportunity to reply shortly to a question posed yesterday related to the case of religious union versus Croatia. It was the enforcement of the decision of the Court for the Human Rights. Discrimination was about state refusal to conclude contracts of common interest, whereby they were denied the right to hold religion classes in public schools and preschool institutions, and an acknowledgement of marriages concluded in those religious communities. On the 12th of September last year, the contract was concluded of such questions of common interest with the religious union Riječ Života, this is the name of the union, and the Church of the and the Protestant Church in the Republic of Croatia. And of course, I will not. I hope I was short. I will not be saying anything more for the time being.
Hvala lijepo.
Thank you very much. If we may continue with our answers, I would propose that we do so. So we got a question regarding the scope or the subjects who can be beneficiaries of the system of free legal aid, that is of the primary legal aid in the Republic of Croatia, in view of our new Legal Aid Act. So as we've said, we have primary and secondary legal aid. Primary legal aid consists of advising and detecting the actual legal problems or legal issues of persons who apply for help, and this is accessible to all Croatian citizens or any child who is found in the Republic of Croatia without company, non-accompanied child. It is also accessible to aliens with temporary state permit, and if there is reciprocity, of course also for those aliens who have a permanent stay, and also to any alien under special protection. We will give free legal aid to any alien who is illegally staying in the Republic of Croatia, or an alien who is on a short-term stay, if these are procedures of passing a decree of their deportation, banning, or return. And these will most frequently be the procedures which have to do with those persons. For free legal aid, asylum seekers can also ask or apply for legal aid, as well as aliens under subsidiary protection and members of their families who are legally staying in the Republic of Croatia. If legal aid has not been provided for them within the scope of a special act. So in the Republic of Croatia, we have tried to extend the group of persons who can be beneficiaries of free legal aid as much as we were able to, taking or considering particularly the type of cases or issues, as well as the nature of their status. And I would like to point out, not as an excuse, but rather as a fact, that there is a standard even in these issues, and that is the Del Sol case, and that's Del Sol verdict of the European Human Rights Court, which has demonstrated that free legal aid is not an absolute right, but that rather each state can set certain limits. So the limits set by the Republic of Croatia have been very carefully measured, exactly with the aim of protecting the vulnerable groups of aliens and asylum seekers, particularly in view of the status they enjoy, and which is typical and characteristic of these groups. We've also had a question regarding the regulation of trade activities, trade in arms, and I would like to pass the floor to my assistant, Mr. Tomislav Boršić, to give a more detailed response to this question. Thank you. Respected Mr. Chairperson, respected members of the committee, representatives of NGOs. Yesterday the question was asked regarding the sales and distribution of arms. Unfortunately, the current situation in the world with numerous terrorist attacks is requiring the international community more than ever to make any efforts in order to control the trade in arms and the distribution of arms. As it has been mentioned yesterday in the question, the Republic of Croatia in 2013 signed the International Treaty on Arms Trade. And it is important to point out that the Republic of Croatia, from the very beginning, supported the international efforts for establishing a standardized form of trade and distribution of arms, but not only trade, but also respecting human rights. In the Republic of Croatia, the body in charge of issuing permits for import and export of arms is the Ministry of the Economy. Based on the Act of the Control of Traffic in Military Goods and Non-Military Dangerous Devices, issues permits for the sales of arms, and we would particularly like to point out that this act stipulates the control of the trade of military goods, and this includes activities prior to issuing the permits, during and after, temporary import and export, as well as services and transfer and transit of goods. It is important to stress that one of the important conditions when applying or when filing the request is the duty of the applicant to submit also a copy of the license. Also, we asked for an original specimen of the confirmation issued to the beneficiary by the state of the end user. Also, when talking about the sales and distribution of arms, it is important to stress that in the Republic of Croatia, the Ministry of the Economy, apart from the act which I've already mentioned, allows permits on the basis of consent of the Committe for giving consent for import and export of goods, of military goods and non-military dangerous devices. This control mechanism supports and contributes to the combating of abuse of arms, the fight against terrorism, and global and regional security. Also, this Commission, when making decisions about the permit for exporting arms to other countries, bases its decision on a joint position, which is defined on the basis of 8 clear criteria, which I'm going to mention now. It is very important that the state into which the arms are being exported respects international obligations, the criteria of respecting human rights and international humanitarian rights in the destination country, and The situation in the state is also important, as well as the criterion of preserving peace and stability. One of the criteria is also national safety of the Republic of Croatia and the territory whose external relationships are within the scope of responsibility of the Republic of Croatia. The behavior of the destination country towards the international community. This is a very important point of view or standpoint of this country against terrorism, respecting international law, and the very nature of its alliances. We also have the risk of redirecting goods within destination country or export in third countries under unwished conditions. And the final criteria is compatibility of goods or technology with the technological and economic capacities in this destination country. To conclude, I would like to mention also that given the geographical and strategic position of the Republic of Croatia, which is in the center of one of the most important European smuggling routes, the so-called Balkan route, and that the capital of Croatia in 29 and the Republic of Croatia in 29 has adopted an action strategy and action plan for the control of arms. This strategy is being conducted by a commission, implemented by a national commission for small and light weapons. And based on this national strategy, the primary activities of the Republic of Croatia are exactly within the framework of control of small and light weapons, is increased activity with the aim of reducing smuggling and illegal production and trade in weapons. With this, I would end my speech, and I hope that my answers were satisfactory. Thank you. Imam još 5 minuta. 10 minuta.
Kao što sam dobila uputu, mi ćemo još u 2 minute kratko odgovoriti na pitanje o psihosocijalnom tretmanu koji je jučer postavljeno i poslije pauze ćemo, ako se slažete, krenuti na set pitanja koji...
As I've mentioned, sorry, I haven't switched it on, so excuse me. So thank you very much. I'm going to repeat, as we have 2 minutes to answer a brief question. I will answer the question linked with the monitoring of psychosocial treatment, and after the break we shall answer the set of questions that had been asked yesterday and that had to deal with the gender equality. So yesterday the question was asked whether the Republic of Croatia had a developed mechanism in place to monitor the implementation of the protective measure of psychosocial treatment, which is in place in cases of domestic violence. The system of psychosocial treatment can be dual. It can be either in a prison institution or a hospital institution. If it is a perpetrator who already does have a psychiatric record, if this is not the case, and fortunately most cases are such that perpetrators do not have a record, then psychosocial treatments can also be conducted outside medical or prison institutions. The way this is being implemented is we have an ordinance and we have standards set for such treatments. To put it brief, the Ministry of Justice, as the institution in charge for organizing the implementation of this measure, makes a tender, organizes a tender, and the bodies in charge are being informed. After the control, they get a permit for the treatment, and after this they also get a decision for implementing the treatment. They're entered into the registry of the Ministry of Justice. The Ministry of Justice has a special registry of all treated persons, and during the treatment and at the moment when financing is requested, a special report needs to be made, and organizers of treatments also are obliged to make joint reports. Apart from this path, from the implementing bodies towards the ministry, we also have the other way around. So starting from the courts as starting points, and from the courts we get feedback on how the courts assess the implementation of the measure for individual perpetrators. So exactly linked with the measures of psychosocial treatment based on the communication with the courts, we have worked out certain points at which we are then introducing measures in order to further stipulate this system. Thank you very much.
Thank you very much, Madam Head of Delegation.
Hvala, gospođo voditeljice delegacije.
Información por escrito al diálogo tiene 48 horas y que es importante que la delegación.
You'll have 48 hours to send written. There isn't. So once again, thank you very much, Madam Head of Delegation.
Mnogo hvala, voditeljice delegacije.
I'd just like to remind you that you have 48 hours to submit written to the committee, and it's important that the delegation assess what information you send us in writing and what information can be more useful for the dialogue which we are having. We seem to be having a problem. The microphones seem to be cancelling each other out with the English and the Croatian, but I think it might be resolved now, says the English interpreter. So once again, says the chairperson for the third time. Let's see if all microphones are properly on. So, third time. Just to remind the delegation, you have 48 hours to submit information in writing. And it's important for you, the delegation, to assess what, out of this information that you give us, what you send us in writing and what you send us here, or what you tell us about here, so that we can have a more useful discussion in the light of what colleagues have raised. So we move on to our second part of our list of issues. These are very important issues and we need time to tackle them properly. So without further ado, I will turn to my first speaker on my list.
On my list is Mr. Nigel Rodley. Sir Nigel, you have the floor, sir.
Thank you very much, sir. I'm afraid you're stuck with me from issues 13 through 18. 13 and 15 are a cluster relating to war crimes, crimes against humanity in the past, in the 90s, and similarly 16 to 18 are a cluster relating to treatment of detainees, though somehow one dimension of that seems to have crept in already prematurely. First of all, issues 13 to 15 on the situation of the past. And I'm struck, going back to the committee's concluding observations in 2009, that the committee remained concerned about reports that many potential cases of war crimes remain unresolved, and that the selection of cases has been disproportionately directed at ethnic Serbs. It notes the low number of cases prosecuted before special war crimes chambers. And I have to say that the answers we've received so far don't seem to be terribly reassuring. The answer to issue number 13 begins at paragraph 137, a working meeting of the Chief State Attorney, municipal and county state attorneys, officials of the General Police Directorate, and commissioners of police administrations of the Republic of Croatia was held in mid-December 2012 with the aim of undertaking activities in the field of investigating and prosecuting war crimes committed during and after Operation Storm. So that's 3 years after our concluding observations. What seems like a fairly preliminary meeting was convened. It doesn't connote a great sense of recognition of the immediacy of a problem that was already unduly protracted. And I'd be interested to know why it took so long to have such a meeting. I do appreciate the information about the one case mentioned, the Grubori case. I'd be interested to know how the delegation accounts for the 75% acquittal rate in that case for people prosecuted, 3 acquitted. I'd be interested in knowing what the sentence imposed was on the one person who was convicted, and whether the decisions have become final. And in relation to the acquittals, it would be interesting really to know why. Was it poor evidence? Was it a poor prosecution? Or was there some problem with the court that one could speculate about? Either way, not too encouraging. Is there any more information on the 2 national priority cases mentioned in paragraph 140? Because I recognize that the report is already 2 years old, but I didn't see any updating information in the introduction from the distinguished head of delegation. I also note the problems of cooperation with the ICTY, and was reassured by the head of delegation's mention of a new memorandum being concluded with the follow-up court to the ICTY. But I'm still not quite clear. The impression seems to be that without that cooperation, somehow things couldn't go forward. And I'm not quite clear why the state party wasn't in a position to do its own investigations, and how dependent it had to be on the cooperation from the ICTY. Nor am I clear why the ICTY was apparently not cooperating. What reasons did it give for the non-cooperation after apparently a period of cooperation? Continuing on with issue number 14, again, the information we have, very useful, but it's still largely about plans. I note the identification of the 4 largest county courts being given jurisdiction over international crimes. The fact is that we're also informed by civil society that these courts have been given no extra resources. Could the delegation explain how these courts are then expected to undertake the complex and unaccustomed work involved in war crimes and international criminal law cases without the extra resources that would normally be expected to be needed? At paragraph 146, the report says that, or the response says, they're the same, the current progress achieved with the discovery of perpetrators in 6 of 8 national level crimes and in 11 regional level cases give us grounds to conclude that what we have planned is attainable. I'm not quite clear what this means, national level, regional level, and actually what actions have been taken against whom, for what, and what is the stage of the proceedings. And it would be good to have that sort of information. It appears from paragraph 147 that a lot of the work has been in relation to in absentia trials, either the trials or the reopening of in absentia trials. Perhaps the delegation could explain the priority that had been given to in absentia trials. That said, I do note from the answer to issue 15 that it is now the practice of the courts not to process felonies. I trust that includes all international crimes in absentia, and that actual cases are very rare. But it would still be interesting to know how so much priority was given for so long to those trials, which admittedly were obviously ones against Serb perpetrators rather than Croatian perpetrators. The question we asked in issue 14, amongst the questions we asked in issue 14, were regarded command responsibility and issues of war crimes of sexual violence and crimes committed by senior officials, and there's nothing in the response addressing those questions, and I wonder if the delegation has anything to add. And finally, on the question of victims and witness support, what is described in the state party's response in terms of this provision for victim and witness support is itself, in itself, very encouraging. But I do note from the shadow report of a number of NGOs that well, the following: further expansion of the support to other courts, state attorney's office and the police, that's courts other than the ones where there are facilities, as well as widening the scope of support to provide victims and witnesses with psychological and legal assistance is very much needed. Victim witness support should be provided at the earliest stage of criminal proceedings and ensure its continuity throughout the criminal proceedings, and in particular serious cases also during the execution of criminal sanctions and after the perpetrator's release from serving the sentence, in other words, lifetime support. Could the delegation comment on the extent to which the concerns expressed by civil society on the adequacy of victims and witness support reflect continuing concerns? Let me now move on to issues 16 to 18. These will be substantially briefer, you'll be pleased to know. First of all, with regard to issue 16, our question was not just about pre-trial detention in the sense of remand detention ordered by a judge, but also pre-trial detention in pre-trial detention, if you like. Let's say detention in police stations, essentially, before formal remand detention. And while I'm grateful for the statistics we have about pre-trial detention, it would be useful to have to know if there are any statistics, comparable statistics, in relation to detention in police stations. Generally, in relation to that issue, I'm very pleased to see that there have been very few cases of torture and ill treatment. It would be interesting to know whether there have been any cases since the report's drafting. Certainly, I have to say that we're not getting either from civil society or from the Ombudsman any complaints of a continuing problem of torture and ill treatment in police detention, and this is very encouraging to hear. In regard to the one case where there was a conviction for ill treatment, it would be useful to have details regarding what the acts were and what was the sentence imposed. There were apparently all three victims were compensated. Well, no, let me rephrase the question. It's not clear whether one victim was compensated or whether all the victims referred to in paragraph 166 were compensated. And was it, in other words, was it only the one was, I'm sorry, sir, I'm going to say this again. Was the one perpetrator was convicted. I presume the victim of that perpetrator was compensated. Were the other victims, where there was no conviction, compensated? Got there eventually. Issue 17, this is relates to conditions of detention. Again, I appreciate the data given by the delegation and in the response regarding convicted prisoners and the increased use of probation in lieu of detention. It's also clear, nevertheless, from the Ombudsman's report that much greater use could be made of non-detention options. I was reassured to hear from the head of delegation that there is now sufficient capacity to accommodate the existing number of prisoners. This in itself would be reassuring in the light of the previous continuing problem of overcrowding. But I still have to go a little bit further because it's sometimes possible to have a global view where capacity and population match, but that they don't necessarily match in individual places of detention. And I note that from the Ombudsman, no less, in some prisons the occupancy rate is higher than 140%. In Osijek County Prison it's 150%, 157%. In Požega, forgive the pronunciation, County Prison, it's 142%. In Varaždin County Prison, it's 140%. So I'd like perhaps a little bit more detail as to whether the problem of overcrowding has actually been solved in an institution on an institution by institution basis. And certainly those levels of overcrowding are serious and potentially oppressive for those subject to them. And apparently this is an area where the European Court of Human Rights has also had occasion to consider the problem. So can the delegation explain what is the target, not just to reduce, but to end overcrowding in all detention institutions? There's also an issue of health treatment in places of detention. The Ombudsman has drawn attention to this, and I'm wondering if the State Party will be responding favorably to the Ombudsman's recommendation that these services be transferred to the Ministry of Health. This certainly often is a solution that commends itself to states, since prison health services are notoriously difficult to maintain effectively and at a level commensurate with the outside world. Finally, on issue 18, the one where there's already been some discussion, and I'm not sure I kept up with it entirely, and if I haven't, I apologize in advance. First of all, let me say how pleased I am that what the State Party calls enclosed restraint beds have been abolished, cage beds or net beds to the rest of the population have been abolished, and that conditions in mental health facilities of such things is subject to monitoring, and indeed I note that prison monitoring has found none, and UNICEF monitoring in one child institution did find it, and it was immediately abolished. I note that the National Mental Health Strategy has set appropriate guidelines. I think we've heard some of that already. But it would be interesting to know now what is actually being implemented and what the results are. Again, I note that the Ombudsman for Persons with Disabilities continuously warns about the grave situation of persons with psychosocial disabilities due to a complete lack of outpatient treatments and any form of community-based services. Is that wrong? And if it's not wrong, what is the State Party contemplating to do about it as a matter of urgency? Those are my questions. Thank you very much, sir.
Thank you very much, Sir Nigel. Now I pass the floor to Mr. Bardellashvili. You have the floor, sir.
Thank you very much, Chair, and I want to thank the delegation for the information provided yesterday and this morning. The first issue on my list today is trafficking in persons, but before moving to the issue, with your permission, Chair, I would like to, probably in a form of follow-up questions, let me kindly remind the delegation a few of the questions which I had yesterday, and unfortunately I didn't have a chance to hear the responses, and I apologize if I missed something during the responses provided. There were questions related to the measures or procedures available in Croatia for the implementation of the views of the committee, and I am particularly interested to learn whether it is for instance, whether it is an absolute discretion of the state to provide the remedy to the author of the communication in cases when the committee finds the state in a violation of the covenant. Does the state provide the remedies on case-by-case basis? Well, what are the criteria? Or maybe there are formal procedures in place which the author can invoke or rely on as a result of the decision made by the committee and follow-up of the decision made by the committee. There were also a few questions related to the rights of non-citizens and whether the Constitution provides sufficient guarantees for foreign nationals and stateless persons, especially taking into account that in some cases the Constitution as well as laws refer particularly to the citizens, and in cases when it does refer to aliens, whether it covers stateless persons as well. Of course, I don't insist on the answers to be provided right away, and of course, delegation, if it wishes so, may respond in writing. But I would very much appreciate the responses. Now, to move to the first issue on my list. And that is the trafficking, as I already mentioned. Let me start while acknowledging the efforts of the government in fighting this problem, and in particular adoption of the national plan for combating human trafficking for the period of 2012-15, as well as the introduction of rules and procedures aiming at improving support to the victims of trafficking. Let me also share with you some information which raises concerns. The European Commission, in a monitoring report for Croatia's EU accession, noted that Croatia's sentencing for trafficking crimes remains lower than sentencing for other organized crimes, and thus was insufficient deterrent. It should be also mentioned that Croatia fortunately moved from Tier 1 in 2011 to Tier 2, to best knowledge, in 2014, according to the U.S. State Department assessment. And this is particularly unfortunate development, especially taking into account that action plan for 2009 and 11 has been developed and implemented with a view to introduce the long-term or sustainable solutions to the problem. And I would appreciate, of course, if the delegation could share its views regarding the reasons for such drawbacks, let's say, so the reasons for such problems, and to what extent these reasons, which in a way resulted in a worsening of a little bit of a situation, have been reflected in the new action plan, which was developed and adopted recently. It has been also reported that Croatia directed its efforts to carry out criminal investigation or to improve the criminal investigation and the prosecution. However, overall number of the prosecutions and sentences were too low, as I already mentioned. And it is true that trafficking in Croatia remains, according to many experts, it is true that the trafficking in Croatia remains considerably higher than that identified by the government. Well, for instance, in the period of 2012 and 14, 173 or 75 victims of trafficking have been recorded, according to some of the reports, while according to the Walk Free Foundation report, it is estimated, and to the UN reports as well, it has been estimated that there are around 18,000 individuals who potentially could have been trafficked to Croatia or through Croatia. And apparently there are problems with or the needs to improve the identification of victims of human trafficking. there have been also quite some difference in the numbers. Some international organizations reported the number of convictions for the trafficking offenses, which was actually higher than the numbers reported by the state. There was no big difference, but still there were different numbers. For instance, there were in international reports you could find convictions of 7 persons in 2011, and while again the state report provides for a lower number, and I was just curious what might be the reason for such a discrepancies. Although penalties for trafficking offenses are sufficiently stringent, it has been also reported that in practice, trafficking offenders receive prison sentences ranging from 1 month to 3 years, and only in one case, and to the best of my knowledge, offender received sentence of 9 years. Could you please comment whether this information is accurate, and what are the reasons for such? Or what might be the explanation for such a sentence? While it should be also acknowledged that the Croatian government sustained its victim protection efforts and provided trainings for the law enforcement officials as well for the judges in how to deal with the victims, many experts and international reports indicate that there is a need to improve that, to improve the victim identification measures, strengthen the measures. And in that regard, there have been a number of recommendations to deepen the cooperation with specialized relevant NGOs who, for instance, work on the issues of, or we provide support to the, for instance, sex workers or individuals who are engaged in prostitution, so they could provide useful information to the government. So I was curious whether I noticed that there was a reference to the cooperation between the governmental agencies and NGOs. So I would be interested to learn if that type of cooperation is also covered. Let me now move to the next issue, and this is issue number 20. Which deals with the problems of sustainable solution for the internally displaced persons and returnees to the state party. Well, I myself come from the country which unfortunately has to deal with the problem of accommodation and integration of IDPs and the refugees, and I realize how difficult and complicated the process is. And the report of the State Party, as well as other sources, provide impressive figures reflecting both the amount of the investment made by the state and with the support of the donors, as well as into the housing construction and rehabilitation, as well as the numbers of refugees and IDPs being able to return to Croatia. And these numbers are impressive, as I said. Some programs led to the repossession of more than 90,000 private houses in Croatia and the reconstruction of 149,000 housing units. And it also was reported that the ethnic Serbs who were forced to leave the state had a possibility to benefit from these programs. A big number of them. However, the concerns remain with the pace as well as with the nature of the program. And for instance, the concerns have been expressed that starting from 2012, implementation of, I think it was housing care program has slowed down. It has been indicated that only 177 families benefited from this program in 2012, which is 1/10 of the number who benefited previous year in 2011. And in 2013, this number decreased further. Apart from that, it was, according to the UNHCR's report of 2014, a majority of the estimated 30,000 refugee families who lost their tenancy rights, were unable to get a repossession nor the compensation for their lost property. I would appreciate the comments of the delegation on these numbers as well. It has been also reported that the local authorities in some areas are in practice discourage the return of some of the refugees, and in particular refugees of Serb refugees. And various organizations, including UNHCR, expressed concern that lack of access of returnees to basic services and public utilities creates an additional obstacle to the successful implementation of the program. And it has been further reported that these challenges are even more difficult to overcome. It puts the Roma community or the Roma minority even in a more difficult situation, taking into account that they belong to the most marginalized group anyway. These are my questions today, and I again would like to thank the delegation in advance for the answers to be provided. Thank you very much.
Thank you very much, Mr. Bardalashvili. And now, el próximo orador en mi es el...
The next speaker on my list is Mr. Rodriguez Garcia. You have the floor, sir. Thank you very much, Chairman, and thank you very much to the delegation, which has spent a certain amount of time to give us responses yesterday and today. I have a few follow-up questions today. Some of them refer to things which were mentioned yesterday, but there's also a new topic which I want to mention, namely freedom of expression, freedom of association, freedom to demonstrate, and so on. From the report, I did get the impression that there are legal restrictions and limits on the freedom of expression, and there's the crime of defamation. So there are these restrictions, and these can sometimes be grave threats to democracy, structural problems, I believe, which sometimes affect journalists raising cases of corruption, and there are concrete cases of this. Corruption's very important as a topic in a democracy, and it's of concern to us that there are incriminating acts or acts by which threats are delivered to journalists investigating cases of corruption. And so I have a specific question about attacks which occurred in 2008 and 2010 affecting journalists who were investigating corruption cases. Dosko Milius, with apologies for my pronunciation, is one journalist who was investigating corruption. I've looked at the information about this, and what we've received from the state party is that a criminal procedure was carried out against an individual relating to an attempted murder, and yet no perpetrator has yet been identified in that regard. A number of criminal investigations took place, but the proceedings were more or less dropped after a period of 4 or 6 years. Stepan Mesarik is another case, and information on this is even more scant. It's stated by the state party that a complaint was lodged in that regard, but we don't know what the status of the proceedings are. We don't know whether perpetrators have been identified. And it said that the Municipal Court of Cacuec has received a complaint, but this complaint has now existed for 4 years at a very incipient stage, and no progress seems to have been made. So I go back to the structural matter. Croatia is number 65 in the global rankings for freedom of the press by Reporters Without Borders. And I know that many situations need to be analysed and resolved. For instance, the Ministry of Culture has not honed a strategy for coherent policies on ensuring democracy in the media. And so there's an excessive concentration, for instance, of media ownership. The main concern here is that there's also been a reduction in the capacity for journalist jobs to be absorbed. So this concentration of power through media ownership means that journalists who do secure jobs have to fall in line with often restrictive media policies, and so a sense of self-censorship arises. I don't know whether it's worse for legal restrictions to be in place or this self-censorship, which for systemic reasons or due to media ownership is shouldered by journalists themselves. Either way, I think this situation is rather problematic. I think if I, as a journalist, lose my job and have no prospect of securing a new one, I'm unlikely to lodge complaints, particularly, or raise concerns, particularly where corruption's concerned. There are other threats to freedom of the press through, for instance, the Criminal Code of 2013, which mentions the crime of defamation. This can go against journalists, including when they publish verified empirical data. So we're not even just talking about opinions here, we're talking about a law which can penalise journalists who publish real data. They can be punished for that through the element of the criminal code which relates to defamation. There's a case in which this has been applied where a judge handed down a guilty sentence to a journalist which had raised a case of corruption on the part of a private sector company. The judge deemed that this wasn't in the public interest. It's a corruption case, I repeat, although a ministry was involved in this. The Court of Appeals annulled the decision, but the provision remains in the criminal code, and so it's very likely that further cases such as this will arise and poor interpretations of this provision will be handed down. One case caught my attention in particular. RTL Broadcasting Company is a company that was accused of having broadcast a live interview with none other than the Prime Minister, who'd criticised the Mayor of Zagreb. The Mayor of Zagreb launched a proceeding against the company, and all media informing the public about the statement were criticised. This is quite a classic case, in my opinion. The decision stated that RTL Broadcasting shouldn't have broadcast a live interview without first editing it, which suggests that the media have to be tied to this prior censorship. This is quite remarkable. I have a respectful recommendation to make in this regard. Firstly, the provision in the criminal code should be amended where defamation is concerned. And obviously, attention should be raised and training should be given to judges concerning the application of the basic principles of the freedom of expression and matters relating to corruption and so on. Another area of concern, and this relates to freedom of association, is restrictions and violence and hatred relating to gay pride marches which took place in 2011. At least 5 people were injured by counter-demonstrators who threw stones and other objects. The state should be promoting and fostering a culture of tolerance towards differences, in particular in this case the LGBT community. I'd like to summarise a number of matters relating to issues 23 and 24 now. And this relates to the right of persons belonging to minorities. The first relates to issue 24. What measures have been taken to protect national minorities relating to proceedings in relation to nationality? We've heard a great deal from the State Party related to the legal framework, but I have a few more specific concerns. For instance, bad police practices. I've read that there's one police practice which involves maintaining an ethnic profile, which is sometimes one which involves incriminating systematically the Roma population. This involves apprehending Roma individuals outside their dwellings with virtually no justification, and the only grounds for this seems to be ethnic in nature. They're often arrested for various different felonies, including assault and theft. And this can also take place in places such as the Porin Hotel, which is linked to asylum seekers. So what measures will the state take to combat these bad practices at the administrative level? There seems, in addition to this, to be a lack of political involvement in the matter, particularly where the Serb and Roma populations are concerned. There's a lack of representation of those populations in political decisions and in administrative bodies, and this is at various different levels. We're familiar with the plan which has been established for public sector employment for minorities, and the goal behind that plan is to increase involvement and representation of those minorities by 5.5%, but we've not seen specific outcomes of this. I won't refer to specific statistics, they're much lower than the targets, but the question really is what is going to be done to implement this goal of 5.5% increase in employment and in participation in decisions. In the law on the rights of national minorities, we've heard a great deal about that law, and I won't ask for further details, but I do want to raise a concern about that constitutional act on the rights of national minorities and the results which it's garnered. In relation to certain rights, such as the use of languages and cultures of minorities, access to public media, and employment, shortcomings have been exhibited, and I'd like to know what's being done there. There seems to be no stimulus for the use of minority languages or measures to facilitate access to minority media. So my question is, what's being done to ensure that public or private sector broadcasting companies might foster that access? Whether the measures might be taken to ensure that there are works in minority languages, for instance. Another issue is the right to property ownership for national minorities. The government has a programme which it launched in 2010 to allow property to be bought at lower than the market price. I'd like to observe that in many cases that cannot be applied. It's impossible to gain access to property in that regard because the cost is often 3 or 4 times higher, in fact, than the market price. And so that right isn't always enjoyed. So how can citizens be provided with the means to overcome this? How can stateless individuals or members of the Serb minority enjoy this full panoply of rights? We mentioned yesterday the de facto participation of Roma children in schools, and mention was made of the European Court of Human Rights. I'd like to ask for further details about the following. In spite of the application of basic measures against segregation with which we're already familiar, the problem of segregation of Roma children is one which persists in school environments and in primary schools which are close to settlements which are often almost entirely populated by Roma individuals. I'm referring to Medjugorje, which is an area with many Roma settlements. We have statistical data showing that in the school year 2012 to 2013, 50 classes were still segregated, and that figure is higher than when the government's plan in that regard was established in 2010, and that's when the case of Ursus and others versus Croatia was came before the European Court of Human Rights. So what measures are being taken to reduce segregation in schools? Could we have more information about what plan has been established, what alternative plan might be established to prevent the segregation of Roma children in the education system, and to ensure that that can really apply in reality? Thank you very much.
Muchas gracias. Now I pass the floor to Ms. Pasartits. You have the floor, madam.
Thank you, Mr. Chairman. I will be very brief today. I thank the delegation for some of the responses given yesterday and this morning to the questions asked by the committee. I'm sure the dialogue will continue. Just a brief question on issue number 22, which refers in particular to unaccompanied and separate migrant children, the question. In your response to issue number 22, you mentioned the rules of procedure adopted for children separated from their parents, in particular foreign nationals. I would like to inquire, how have these rules been applied in practice? It appears that the guardianship of minors, concerning guardianship of minors, the provisions applied are the general legislation, the Family Act. So I would like to see how that relates to the particular rules of procedure for minors. My second small question is, how are international legal standards safeguarded, in particular as regards the process of assigning a guardian? There are reports that mainly due to language difficulties, guardianship is sometimes assigned to persons who don't have the necessary qualifications that would assure safeguarding the minor's best interests. So I would like some comment on this by the delegation. And I would like to ask whether free legal aid is available to children, in particular asylum seekers. I understand from your response this morning that primary legal aid is available to everyone. What about secondary legal aid, and what about minors, unaccompanied minors in particular? Thank you, Mr. Chairman.
Thank you very much. Maintenant, je passe la parole.
I now give the floor to Monsieur de Frouville. You have the floor, sir. Thank you very much, Mr. Chairman. I want to put some questions to the delegation and to thank the delegation for all the very detailed answers we've heard so far this morning. My questions have to do with the sad conflict of 1991 to 1995, the consequences of which you have to deal with, and the search for disappeared persons. I'd like to address disappeared persons. The State Party has taken some measures already, and the State Party has made significant progress in this particular area, given that a significant number, a high number of bodies have been recovered according to figures that have reached me. And these figures come from the Office for Detained Persons or Missing Persons in Croatia. A great number of persons have been able to be exhumed and identified, but it would appear that there are around 900 persons still unaccounted for, disappeared persons, and efforts to exhume them and identify them, it would appear, have slowed down over the last few years. So I just would like to hear your view on this. Could we have some explanation as to what measures are currently being taken and implemented to put an end, so to speak, to this effort which you have been making so far? I also like to ask the delegation about an allegation according to which the exhumations allegedly are carried out, or the way they are carried out would indicate there is a bias in terms of the ethnic origin of the victims, and these allegations say that the exhumations occur more frequently for the common graves inherited from the 194 conflict rather than the conflict linked to the military operations of 1995. Thank you very much.
Fort bien, merci beaucoup.
Thank you very much, Monsieur de Frouville, says the chair.
Floor to Mr. Politi. You have the floor, sir.
Thank you, Chair. I do have an additional question of issue number 13, and these along the lines of what has been already so comprehensively noted and commented upon by Sir Nigel Rodley. In paragraph 138 of the report, the State Party indicates that in regard to war crimes committed during and after Operation Storm, the State Attorney's Office of the Republic of Croatia requested from the Office of the Prosecutor of ICTY that they deliver all the materials contained in the files from the proceedings against Ante Gotovina, Mladen Markac, and Ivan Čermak. This in order for the said material to be used in further actions of the state attorneys involved in war crimes, on the prosecution of which competent county state attorney's office are already working. Now, it is also said that most of the documentation for from these proceedings was unavailable until recently, since the final verdicts in the ICTY proceedings were not yet reached. Now, it is my understanding that the final verdict on appeal was reached in November 2012. I stand to be corrected on this, but this is my recollection. So my question is this documentation now available? Has been given to the state attorney's offices? Are they working on these documentations? Are any actions been taken or any action has been stopped after that? I would be very grateful for some clarification on these specific points. Thank you.
Thank you so much. And now I pass the floor to Ms. Shelik. Ms. Shelik, please.
Thank you. I would like also to thank to Croatian delegation for constructive approach to our questions and comprehensive overview in regard to undertaken activities. I'm very well aware of demanding accession process towards EU and all fulfillment of criteria for all 35 chapters, because my country is now going through that, especially concerning the chapter 23 and 24. However, what is important is to hear about more concrete progress achieved since Human Rights Committee last consideration of Croatian report, and in that regard I would just like to ask two questions concerning cultural identity preservation of national minorities. So just would like to underline that Croatian laws are in accordance with international standards, but the practice is still to be improved. There are actually some serious and numerous allegations on violation of the right of equal use of minority languages and script in public. Here, especially, I think of usage of Serbian language and Cyrillic script. So disposal of public topographical signs actually, as far as the information available, are only posted and put in Donji Lapac, or if not only, that is the first topographical sign in public, and still in Vukovar and other 19 municipalities it has to be done. Also, concerning the idea on referendum against Cyrillic script usage in public, Constitutional Court delivered decision on moratorium for 1 year, leaving self-governments to act in accordance in order to implement international standards and Croatian law in that regard. So I would be interested to hear what have been done in that regard so far, and also what are concrete measures undertaken for better implementation of enjoyment of right to equal usage of minority languages in public. And another question is also related to preservation of cultural identity of national minorities, especially concerning national minorities councils in Croatia, which is very positive phenomenon. And I think that these councils are not only good initiative, but also very good mechanisms for better implementation of international standards, as well as promotion of interethnic and international tolerance. However, there are some information that functioning and cooperation between the councils of national minorities and local authorities is lacking. It's not at satisfactory level, and this cooperation is crucial for functioning of these councils. Also, the law actually turnout of elections to the councils of national minorities undermined the democratic legitimacy of the electoral process, which was found by resolution of the Committee of Ministers in that regard, and also concerning funding for the councils, which should be secured through the local self-government units at the state budget, remain inadequate, and that seriously limits the capacity of effective function of the councils of national minorities. So my question would be, what are the concrete steps undertaken to improve that situation? Thank you so much.
Muchas gracias.
Thank you very much. Well, you've had a whole hour of questions put to you. Perhaps that is too much pressure on you. But we will give you 16 minutes for you to put together some answers. We understand you won't be able to address all the issues raised, but we will have to resume our exchange of views at exactly 12 noon. So please, if you may, make an effort, and I'm speaking here to the delegation and to colleagues. Colleagues, when you put your follow-up questions to the delegations, please be very concrete, specific, so that we can all work best with the time given to us. So we pause until 12 noon.
Colegas.
Colleagues. We resume then our session. I'd like again to thank the delegation for its efforts under the pressure which the committee is exerting with its extensive list of questions. Thank you very much. I now give the floor then to the delegation so that it can respond as it sees fit to my colleagues' questions. You have the floor.
Hvala.
Thank you. Perhaps it is a pressure, but I need to say that we are happy to say that we can positively respond to all your questions. They are dealing with the areas that we believe that we have made significant progress, and we intend to demonstrate by our specific and concrete answers. As we have said in the introductory part, for the legal system of the Republic of Croatia, the greatest challenge was facing the consequences of war and repairing the trauma for objective and subjective reasons from the destruction of our country in the aggression that it has suffered. In that part, I will give the word for specific questions to Mr. Tomislav Boršić. Thank you. Since we are short of time, I will reply in connection with war crimes. It will be brief, but I hope very clear. One of the questions was the question of a number of unprocessed war crimes. And of course, for the Republic of Croatia, it's a huge problem. But unfortunately, Croatia was under aggression, and unfortunately there was a huge number of war crimes committed. When we talk about objective processing of war crimes, impartiality, and when the question is posed of why the majority of cases and process crimes are focused on the Serbian people of Serbian ethnicity, I have to say that if we use that logic, we might, the UN ad hoc court for the former Yugoslavia region, we could say that they are unobjective because the majority of the perpetrators are of Serbian ethnic origin. The fact is that at the beginning of the processing that was ongoing even during the conflict, war conflict, didn't include the the members of Croatian military forces, but today this is no longer the case. Today we already have a large number of cases, of process cases, against the members of Croatian military and police forces. There were two questions related to two specific cases about the storm, the case of Grubori. Just to let you know, this case has reached a non-final verdict. I think that it wouldn't be appropriate as a representative of the state authorities to comment on the case that is still ongoing because the judicial system in Croatia is independent. The other case is is the case in Mandici, war crime in Mandici and Proclin, where we have the final verdict in which the one perpetrator was sentenced to 7 years in prison. As for the 3 suspects in this case, the trial was reinitiated, so returned to the initial stage. Also, one of the major issues was the issue of the cooperation with the ICTY. Your question was aimed at the problems, potential problems with the ICTY, but I would like to use this opportunity to dissuade you of that fact, of that notion, and say that Republic of Croatia fully cooperates with the ICTY. If I say that Croatia has so far fulfilled 979 requests posed by the ICTY, we can certainly not say that there are problems, cannot state that there are problems in the cooperation. To return to another major issue, the issue of the Croatian expectation from the ICTY to assist with the processing of war crimes. The reason for that is that Croatia today, the biggest problem of non-processing the crimes is the unavailability of perpetrators and evidence and witnesses to the Croatian judicial authorities. The UN court luckily had an opportunity to gather evidence, to talk to the witnesses, and this is what Croatian authorities weren't able to on occasion. And finally, let me just answer shortly 2 questions and let other colleagues take over. There was a question of national and regional priorities. As I might have mentioned, due to too big number of crimes committed, Croatia had to set certain priorities. Therefore, we have started with 8 national and 119 regional priorities to reach 1 national and 70 regional priorities today. The criteria for setting such priorities are, of course, a high number of victims, cruelty, excessive cruelty, war crimes that have been committed by the order of highly positioned officials, and availability of evidence. And finally, in relation to the chain of command, which is a follow-up on my impartiality comment, and that we cannot say that it is no longer impartial, that is no longer partial, is that Croatia does not process war crimes according that 23 highly ranked officials, members of the Croatian police and military forces, have been processed. So there is no impartiality. There is no partiality. Thank you for your attention, and I'll now give the floor to my colleagues to continue responding to your questions. Thank you so much. As for the specific questions of pre-trial detention, I would like to give the floor to a colleague. In short, in 2014 there has been changes in legislation. The ordinance was adopted on the detainees and arrested persons and detention of such persons in police units. The aim was to remove the deficiencies of the previous ordinance, or to align with the standards of the European Committee for Prevention of Torture and Inhuman and Degrading Behavior, and the recommendations given. The important article I would like to point out is Article 53, that in detail outlines the police enforcement procedures, which lay down the legal basis for dealing with inadequate facilities for arrested and detained persons. Specifically, on the operational level, that means that the Ministry of the Interior aims to, with the budget it has at its disposal, to refurbish and renovate such facilities. And also, we have introduced the system of monitoring of detainees in the way that the officials, the relevant officials in charge for the detainment, systematically and continuously monitor the actions of police officials and officers towards the person that have been deprived of liberty, and inspect the facilities. There is additional progress by introducing records in the IT system of the Ministry of the Interior. Once the person is arrested, the person is recorded in the IT system, and soon after it is recorded what's happening with this person. And that's it. Thank you so much. I will continue specifically with the reply to the question we were glad to get about the condition of Croatian prison. There are data about the previous reporting period. We are aware of such data and we have made significant efforts in the last 3 years to improve the conditions in Croatian prisons, and they have been conducted on several levels: legislative level, at the level of penal policies, in terms of decriminalizations of actions that do not require absolute criminal protection. The other platform was the area of probation and other parts of that, and transferring of that system. Introducing alternative penalties, alternatives to prison penalties, and the third area are construction works. The fact is that the number of occupancy rates, the occupancy rate is adequate. Of course, we have not managed to achieve the absolute requisite measure. We are aware of the fact that we need to increase the occupancy rates in the high security prisons, because they're accommodating prisoners with long-term sentences, and many of them, and also with reconstruction works in less severe prisons. We provide opportunities to change the capacities And I'm pleased to say that in order to make additional progress in the prison system, we had a session of the Parliamentary Committee of the Croatian Parliament in the Lepoglava Penitentiary, the most severe facility in Croatia. And the Ombudswoman was present as well. And on site, we have established that the progress has been made. The session was held late last year. Another question was the level of healthcare. And in this area, we have also made significant efforts. We have hired physicians in our prisons, and we also, every prisoner, no matter where he comes from, by the very fact that he is or she is the prisoner, they have the health insurance and all the benefits that the health insurance offers. Another question that I would like to address is the human trafficking issue. I would like to give the floor to the head of the Office of Human Rights. Thank you. Okay, let's be very short and concise. I would be in Depeche mode. In the Republic of Croatia, we have 3 national strategic plans for combating human trafficking. We are working on the new one for 2016 to 19. We have adopted 3 protocols for identification, help, assistance, and protection of victims of human trafficking. The protocol of safe repatriation of victims, and the protocol of integration or reintegration of victims. The national system consists of national committee and the other relevant bodies. For 10 years, we have had hotline, telephone assistance for all citizens. There are 2 shelters for human trafficking victims, one for adults, the other for children. And both shelters are run by the civil society organizations. And we have extremely good cooperation with them. It's a network called Petra. And they are active participants in all the activities conducted by the government. Every year, the NGOs are financed through tenders. In Croatia, we have internal human trafficking, because most of the victims come from within Croatia. As for the statistics, I'll be very short. For the last 3 years, in 2012, we had 11 victims. In 2013, 31, and 2014, 37 victims. This number of, what was it, 18,000 is completely unrealistic. We are not sure how have they arrived at this number. It means that they're coursing through Croatia on a daily basis. I don't think this needs to be addressed. As for the criminal criminal charges, they're relatively low, but our judges still do not dare to return final verdicts until they are absolutely sure that it is about human trafficking victims. That is why we are organizing additional training sessions. As for the State Department report, that is true, but we have already said to our colleagues in the State Department and showed them the data, and I believe that this year Croatia can be returned to Tier 1. Bilingual situation in Vukovar. Now let's address this issue. So we are the state party of the 2 most important conventions of the Council of Europe for the protection of national minorities and the Charter of Minority Languages. The government of Croatia is with bilingual tables. The Croatia is condemned the and following the positive legislation establishing that if in the area or the city there is more than 1/3 of the members of the national minority, they have the right to use bilingual tables, bilingual labels. In other regions it is honored, but in Vukovar is our Stalingrad, and there is split emotions and people who have suffered great losses, and it's a quite specific situation. The Constitutional Court has adopted a decision in 2014 and established that this initiative for adoption of if there are more than 50% of members of national minority, that only then they can use bilingual labels, which is not in line with many conventions. So this idea was discarded, and it's ordered that the Vukovar City Council issues or adopts a statute, and that the government takes no further steps concerning this situation. To move on, as for the employment of the national minorities, 2012, Article 22 of the Constitutional Act, we call this Catch-22 because it's difficult to realize for the following reasons. For 2012, there were 38% of employed members of the national minorities who were employed. And in reality, it is very difficult to realize because all national minorities are 7.5%. It means that at least that means that two-thirds of the national minorities are employed, which is not so in reality. What is left, the gay parade or LGBT, we should say that according to the statistics of the Office of the Human Rights, and that this statistics does not indicate that the police or state attorney prosecute based on misdemeanor and not criminal legislation, according to the data of State Attorney's Office, due to pre-qualification of certain crimes. We have increased 57 identified crimes. This might be cause for confusion. In 2013, we had 23 misdemeanors, 29 final verdicts, and 8 sanctions. In 2011, there were 57 cases, 45 in hate crimes against LGBT persons. So if we compare that to other years, we see that there is a decrease. To move on, the protection of cultural heritage. Croatia has renovated many sacral objects of Serbian ethnic minority. As for the councils of national minorities, it is a novelty. It is a novelty in the solution of problems of national minorities on the European level, novelty on the European level. There is room for improvement, and it was my office that adopted a decision to fund those local self-government units that are economically disadvantaged. And so on and so forth. There are so many more things to say, but that's it for today. Thank you.
As in the answer, the solving of cases linked with the gay pride in Split were mentioned, and this was one of the questions yesterday. I'm going to answer as for the numbers. So in the misdemeanor court in Split, on this occasion, 65 claims were filed. This was a misdemeanor regarding the regulation on public gathering and public order and peace. And all the cases were solved. In 28 cases, and there were convictions. 8 were declined, and 19 were acquitted. And as there were also minors, for 10 of them, there was protective measure as a sanction for minors. In view of the recommendation which was already given to Croatia and which has to do with criminal laws and defamation as a criminal offense, I must point out that there is an ongoing preparation of a draft of the amendments of the criminal law, and the amendments will have to do with the defamation which you have mentioned, in a way that only the most difficult forms of this offense are going to be sanctioned. So we distinguish between different stages of criminal offenses that have to do with defamation, such as insult, or defamation when someone is also including untruthful statements. And the third will be a difficult form of or severe defamation. If someone is giving a statement which can be true but does not necessarily have to be true, but is doing this with the purpose of endangering the honor of someone. This would be an example if someone would say about our chairperson that he was involved in certain corruptive activities. So such a situation will be a criminal act in case the perpetrator does not manage to prove that this was true. We understand that this is a harder, more difficult part. Or if he or she proves that there was a severe reason for him believing this, or if he had done this as part of the activity which also involves journalistic tasks. If it was a scientific paper or defending a certain right, and everything was done in public interest. So if there is public interest to investigate a corruptive activity, then in that case this would not be a criminal offense, because it is in the interest of us all to uncover to detect such a criminal activity, a criminal offense. And this amendment will certainly be put in place by the end of this year. Given the time left and the fact that the Republic of Croatia is committed to the area of human rights, rights of women and children, I will be free, if the chairperson agrees with me, to use the rest of the time by passing the floor to our head of our gender equality committee, in order to be able to answer the questions that were asked yesterday and to confirm the commitment of the Republic of Croatia in this field, also to continue advancing. Helena, please. Ladies and gentlemen, I am the head of the governmental Office for Gender Equality, which according to the law on gender equality is in charge of coordinating all activities linked with the policy of gender equality in the Republic of Croatia. I believe that the gender equality is a very important element also of the International Covenant on Civil and Political Rights. And I would like, in the first place, to briefly say something about the observations from the first question that our delegation got yesterday, and which have to do with the implementation of the policies linked with human rights in Croatia. So one of the questions was if there was a public discussion on human rights in Croatia. There is an ongoing discussion which has been going on for years, or different discussions on human rights, including also the discussion on women's rights at the national level as well as at local levels. The promotion and expanding of knowledge about the most important international papers from this area, such as the Convention of the UN on eliminating all forms of discrimination of women, the Beijing Declaration, the Pro Forma for Action, Millennia, UN Declaration. All these papers were translated into Croatian. They were published in several thousands of examples. They're on our website, and we have continuously informed the public with the most important activities of the UN, and I think that we've done quite a lot in this area. Nowadays, we'll celebrate 20 years from the ratifying the Beijing platform and declaration. You all know that the UN's conclusion, the Commission for the Status of Women, that large progress has been reached. We all are still challenged with are confronted with numerous challenges in order to speed up the whole procedure of implementation after the year 2015. Croatia also has periodic national strategies for the gender equality, and I would like to point out that the strategy serves more like a compass, which serves as a direction for further activities, and it serves as a basis for the acts, in this case the Act on Gender Equality. There was a question if someone mentioned that there were no indicators. That is impossible. Of course there are indicators, because without indicators how could we possibly do our reports or assess the success of the implementation of our national strategy. As the governmental office, we monitor the implementation of the strategy, and every 2 years we report on the implementation of the strategy, as well as of each of a total of 93 measures. We also mention the success, the challenges that we will have to confront in the future. It is very hard for me to define, and usually we do it, the efficiency of the implementation of our strategy. The result were many other gender-sensitive national papers, such as the strategy for the development of the entrepreneurship of women for the period of 2014 to 2020, or the national plan for the implementation of the UN Council Resolution 1325, as well as a whole range of special measures which were introduced in line with SIGAL, and also the level has been raised of awareness on gender equality and unacceptability of any forms of gender discrimination, which we monitor in a way that we conduct researches on the concept of gender discrimination, so that we can measure the way the standpoints of our citizens change and alter. The strategy has also contributed to the development of gender-segregated statistical data. It has contributed to establishment of a whole range of various gender-sensitive documents. For example, our Ministry of Defense adopted a special policy of gender-aware policy, gender-sensitive policy. Also, our Ministry of the Interior has made gender analysis and issued instructions on the use of gender-sensitive language. I would also like to mention political participation of women. We conduct regular campaigns for a larger share of women at all levels of elections. This year, Croatia has the first female president, so the Croatian population has elected a woman president, and as you know, this is the 11th female president, state president in the world. So there is progress, it is visible and can be identified. Of course, we are confronted with a whole range of other problems which we'll still need to solve. As for NGOs, I would also like to repeat that they are included in the making of all relevant strategies, programs, and legal papers. And also, NGOs are regularly financed from the state budget, and also we regularly conduct and implement common projects with the NGOs. So we work on the implementation of joint projects. One of such projects which we are working on with two non-governmental organizations and which has to do with combating violence against women and was financed by the European Commission is a campaign which is going on for the second year. Now we've come to the issue of the rules of procedure in cases of sexual violence. This protocol, this rules of procedures and distribution is a part of the campaign. We have distributed it. It was published in 5,000 examples, and different ministries such as Ministry of Health, of Education, Science and Sports, and many more are the institutions who are in charge of the implementation of the rules of procedure. It is not a strategy, as it has been said in the question. These are rules of procedure for the offices in charge in cases of sexual violence, where Croatia has also separate rules of procedure in case of domestic violence. So these are really rules of procedure which are in power, in effect, along with our Act and the national strategy for combating domestic violence. Within the framework of this project, we have translated and published also the Convention of the Council of Europe for eliminating all forms of violence against women. We have 8,000 copies, which we continuously distribute, and there is an ongoing discussion in Croatia on the ratification of this, also with the 1325 resolution. It is important to say that this month the Croatian Parliament is supposed to adopt an act about on victims of sexual violence in the homeland war. And this is a very important paper which I believe is going to help us and support the victims of sexual violence with which we were confronted in the 90s. There was another question also regarding the position of rural women, of women in rural areas. This is also a very important issue when talking about improvement of the position of women, also with women with disabilities and LGBT women. Our Ministry of Agriculture has organized a whole range of seminars and workshops with the representatives of organizations of women in rural areas as part of preparations for the action plan, which is meant to improve the position of women in rural areas. This action plan hasn't yet been adopted. I hope it will be adopted by the end of this year. One of the reasons for this delay is also that we are waiting for a new program of rural development for the period until 2020, which has to be ratified by the European Commission. The European Commission had a whole range of comments, but what we were lobbying for was to include also the gender, to incorporate also the gender dimension in this, and we believe that this will have effects, particularly when we're talking about different projects and grants to different NGOs who are working in the rural areas, where we wanted to also include and stimulate and encourage women in rural areas, entrepreneurs in rural areas. And this is also part of our strategy for the development of women's entrepreneurship, which is also an area in which in the past years we were able to achieve large progress, because we work a lot on developing and supporting women's entrepreneurship in the Republic of Croatia. Thank you.
Thank you, Helena, for the exhaustive report on the gender equality and the women. And last but not least, children. I think we need to say a few words on the protection of children in domestic violence cases. I would like to give the floor to the colleagues. Thank you. Thank you. I would like to follow up on everything that Mrs. Radin said, and then specifically talk about shelters. Concerning the question that was posed yesterday, of course, I will not repeat that within the domestic violence policies, there are two-year reports. The indicators have been set, and the report to the governments are regularly submitted, and that's how we are monitoring the situation. How do we promote recommendations of the human rights committees and other committees? In the following way: we align the normative legislation and non-normative acts, and this is how we get our strategy. If some activities are not as fast as we would like them to be, we revise our strategies and align them with our priorities, and that is to acknowledge the recommendation of the committee. I need to say that in Croatia, for the past 10 years, we have legislation that regulates the protection of women in domestic violence cases, and generally domestic violence cases. And it's been more than 20 years since the first shelter was opened. We can say that there are resources for efficient social response to the domestic violence. We have effective legislative framework, and there are resources for providing protection and strengthening the victims and the treatment, psychosocial treatment of the perpetrator. Not only that, in the recent years, there has been a strong political will to prevent such violence. The main challenge that Croatia faces at the moment is raising awareness of the existing protection of the victims and ensuring practical implementation, as I already said, both in legislation and strategies and in implementation of human rights committees and other committees. Furthermore, Croatia has acknowledged the need to strengthen the trust in public institutions and the state's ability to respond to such violence in an effective way. As for the funding of shelters, of course, it is very important that the victims are well provided for. But before I say anything more, I would like to point out that the issue of violence in Croatia is dealt with on an interdepartmental level, meaning that more ministries are included. Not only ministries, but civil society organizations. We have the representatives of the ministries and the civil society organizations. The national teams act through county teams at regional level, where we also have the representatives of institutions that deal with domestic violence. And in that way, we have a good insight on what's going on in the field, what really is going on in the field. To return to the funding and models of funding, the Ministry of Social Policies and Youth, Croatia does not own any shelters. We have dealt with this question through partnership with civil society organizations. The shelters are funded through two basic models. One is through contracting system with the social welfare institutions, and the other is through tenders. The tender is published for 3 years programs, and then we finance them. Why? Why two models, and what's the difference between them? Speaking of contracting services, the ministry concludes contracts with certain organizations for the temporary accommodations of women and children victims of violence. It's not just about the accommodation, but the personal hygiene, social and psychosocial treatment, providing such services for the victims of domestic violence. The victims who get the certificate to live there need to be issued a permit from the social welfare center, and the social welfare centers transfers the funds to the institution, to the shelter. 3,200 kuna per service provided, which includes the counseling, psychosocial treatment, and everything else. Just to illustrate the point, this is 3,200 kuna is approximately 57% of the average salary in Croatia, which means if a child and a woman arrive, it's 115% of the average salary. The analysts have arrived at that amount, and that we believe that such amount covers all the needs of the beneficiaries. What is interesting to mention is that when the service is provided, accommodation service is provided through the social welfare network, it is important that the service is defined through an ordinance on minimum requirements, so that the civil organization, society, or religious organization need to meet minimum preconditions. It's not just about minimum preconditions. We have adopted an ordinance on the quality of social services. We have 17 standards, quality standards, that such organizations need to abide by. I would single out several most important ones: the accessibility of information, the accessibility of service to the victim, complaints as to the accommodations and treatment. So the quality standards are not rigid. They are modified and continuously upgraded. As for the civil society organizations that are funded by tenders, through tenders, they receive fixed amounts on an annual basis, on the basis of 3-year contracts. The transparency of their operations is a bit lower. They do not necessarily meet the minimum requirements, quality standards, but they can always switch from one model to another. I don't know if this response is satisfactory. We have research on shelters and unaccompanied children. No? Okay, thank you.
Thank you very much. Just to remind you, you will be able to send us written information after today. I'm going to give colleagues a chance to put follow-up questions to the State Party, which of course the State will be able to answer in writing, but I think it's important that we give colleagues the opportunity to say something else at this stage. The first speaker on my list is Sir Nigel. Sir Nigel, you have the floor.
Thank you, sir, and thanks to the delegation for the responses I've received, especially given the time. I won't react in detail to some of the rhetoric, such as a concern that the possible bias against possible Serb suspects is no different from the possible bias of the ICTY, which of course has an all-Yugoslavia mandate rather than a republic-specific mandate. I'm still slightly worried by the seeming complacency regarding the situation of conditions of detention, and the Ombudsman is telling us that in Zagreb County Prison, the dormitories are 16 square meters, up to 7 prisoners are in them. The table on which they eat is located next to the toilet, which is inadequately separated from the rest of the room by a barrier not reaching the ceiling, and because of the insufficient number of chairs they eat on, because of the insufficient numbers of chairs they eat on their beds. Prisoners spend 22 hours a day in such conditions. And despite a Constitutional Court decision in 2009 to be implemented in 5 years, the necessary works have not even begun. Now, if this information is inaccurate, I'd like to have that corrected, obviously. To the extent that it's not accurate, I again repeat my question: what is the timetable to have adequate conditions in all places of detention in Croatia? And I look forward to receiving that information and all other information that the delegation wants to bring forward in writing. Thank you very much, sir.
Thank you, Mr. Muhumusa.
Thank you very much, and I hope to be brief. I found it interesting that arms dealings and export fall under the Economy Ministry, as if to emphasize the economic benefits while relegating to oblivion the other important concerns such as international peace and security. As government, aren't you concerned that there is continued presence of Croatian arms in areas under the ISIS-affected regions? Surely better measures could be stepped up to ensure that Croatian-manufactured arms do not end up promoting terrorism. And that's the end of my inquiry.
Thank you so much. Now, Mr. Rodriguez Recia.
Gracias.
Thank you. Very quick question. Minorities and people with disabilities, especially with mental disabilities. There's excessive use of institutionalization of people with a mental disability. The data are that over 9,000 people with a mental disability, 1 out of every 500 Croatians appears to be institutionalized. So my question is, do you have a deinstitutionalization plan? In other words, are you planning to strengthen the family and community care centres to care for people with mental disabilities so that they do not become victims of policies that cause them to be invisible? Because 70% of that population has become disabled, and their legal rights have been seriously infringed. Thank you very much, Mr. Vardashvili. You have the floor, sir.
And thank you very much to the delegation for the answers. Let me very briefly comment or have a question in relation to the estimated number of victims of the trafficking. The number which was mentioned here is indeed very high, and I would share the position of the delegation that it's indeed a troubling number and might not be realistic. However, and I'm not going to defend this number, it was not my intention. My intention was to offer delegation possibility to reflect on the issue of concern. But by referring to this information of this organization, I should mention that this number includes victims of sexual and labor trafficking from the point of view of this organization. And let me also recall that International Labour Organization estimates that globally there are around 4.5 million people trapped in forced sexual labor, exploitation, and around 14.2 million trapped in labor traffics. And these numbers also sound quite, these are also quite big numbers. So I would appreciate, and I appreciate information about the planned activities as well as implemented activities, especially in that area, and would appreciate the information about the estimates. What is an official estimate of the number of victims of both sexual and labor trafficking? And thank you very much.
Thank you so much. Monsieur Frouville.
Mr. de Frouville. Thank you, Chairman. I understand that the delegation can't respond to all the questions, but I would just like to repeat my question about disappeared persons and ask whether some written responses to that could be provided. Thank you.
Bien, merci beaucoup.
Thank you very much. I don't believe there is any time for responses now, but the State Party will have 48 hours in which to offer its written answers to our questions. I'll now give the floor to the head of delegation for her concluding remarks at the end of this very intense two-day dialogue. Thank you.
We will have the written statement, but I can answer two questions immediately. The reconstruction of the Zagreb prison is underway, and it will certainly be reconstructed or renovated by placing toilets in the cells, jail cells. The plan and program is set. The very construction works are about to start. As for the outpatient care for the persons with psychosocial disabilities, Croatia has developed system of out-of-patient system care. And this new act that I mentioned introduces the outpatient care. So this number that you have mentioned is no longer standing. Not to say anything more, let me just use this opportunity to thank Mr. Chairperson and all the members of the committee for the patience and the attention that they have committed to the protection of human rights in Croatia. Thank you, everybody in this room, especially the NGOs. I would like to especially thank the technical staff that provided all technology. And of course, I would like to thank our interpreters that have enabled us to communicate And without a doubt, what is most important, we are here to make the world a better place. And we hope that the Republic of Croatia will contribute significantly to that fact. We will be happy to integrate your recommendations in our efforts. Thank you very much.
Thank you very much.
Hvala vam lijepo.
Un diálogo muy interesante con muchísimas.
An interesting dialogue, and we've heard many interesting aspects. Enforced disappearances, war crimes, crimes against humanity, cooperation with the ICTY. Non-discrimination, women's rights, gender-based violence, freedom of expression, the matter of defamation, which was referred to earlier. If a public figure is accused of a crime, that forms part of the public debate, as the European Court of Human Rights has said on so many occasions, and we should accept those accusations as part of that debate. Fundamental matters relating to prison conditions have been raised. These are some of the main points which have been raised at these meetings. The committee will submit its final observations, and we hope that the State Party will offer further information over the course of this 48-hour period now allotted to it. We'll obviously have a follow-up procedure at the next review. All that remains then is for me to wish you a very safe journey home, and I also thank the interpreters for their extra time. The session stands adjourned. Thank you.